So let's widen that debate on hate speech. Look at the legal and policing aspects. Joining me now, CA Aryama Sundaram, Senior Advocate, Supreme Court, Shadan Farasat, Advocate at the Supreme Court, and also joining me, Neeraj Kumar, former Commissioner, Delhi. Appreciate you joining us on the show tonight. Let's take each of you on that question. What will it take to end this cycle of hate speech, Aryama Sundaram? You've got in Parvesh Verma, someone who's really a repeat offender. And yet at no stage has the law acted against him. It almost seems it gives him impunity to say what he wants, including an economic boycott of a certain community, which in this case is a clear reference to Muslims.
Well, the point of it, Rajdeep, is very simply put. Nothing is an offense which can be punished unless there's a statute which makes it an offense. It goes against your very rights under Article 20 and 21 of the Constitution to punish somebody for something which has not been statutorily laid down as an offense.
No, Section
so
153, one minute, sir. Section, are you saying, no, sir, 1 minute, Section 153 and 295A, are you saying that they cannot
exactly.
operate?
I am saying you have to bring it within the four corners of that section. What we really need is something far more serious, far more stringent. The 295A, what does it really say? It says if anybody with malicious intent wants to outrage a religious feeling and wants to outrage religious sentiments, so within that broad framework, you can definitely bring in a lot of actions against people for doing so. But the concept of hate speeches and to put an end to it, I don't believe is something which can be cured by a mere punishment with fine or imprisonment up to 3 years. It is, if you really want to give a message, it has to be far more deterrent. It cannot be something where you rap somebody on the knuckles and say, all right, now go on your way. So he would do it again. So the fact of the matter is, secondly, there is no provision that for a second offense, a prison sentence of a certain period is mandatory. Even that is not provided. So what happens is, as long as you have people who are willing to behave in this fashion, unfortunately, to deal with such kinds of people, you need very stringent laws. Now, these people, to stop them, you need laws far more stringent than they are today. Otherwise, basically, they are not bothered about the law. They are not bothered about being charged. They are not bothered about being proceeded under 295A. And that's a sad fact.
Okay, so you're saying that the laws simply at the moment are not stringent enough to act as a deterrent. Mr. Farasat, do you believe that the problem lies in the weakness of the law or just in the way the enforcement machinery operates, that the Virat Hindu Sammelan can go on conducting these meetings even though today the Supreme Court pulled up the Delhi administration and the Uttarakhand administration as to why had they not acted on previous such Sammélans where hate speeches are made?
See, I agree with the sentiment of Mr. Sundaram that this is very outrageous in terms of repeat offenders and they are not easy people to deal with. But I don't agree with him that the law is not sufficient. See, 153B, what he has said, what Parvesh Verma has said is covered directly by 153B. That is to say, and 153BB asserts, counsel, advises, propagates or publishes that any class of person by reason of being member of any religious group be denied or deprived of their right as citizen of India. That's exactly what he has done. It's definitionally covered by this, right? Now, 153B may not be just sufficient in a case like this. In fact, in my view, this will even be covered under UAPA. These kind of statement, the law is there. If UAPA is used for all kind of innocuous sundry speeches where it doesn't apply, but in a case like this where 1/5 of the country's citizens, you are actually trying to disempower them and say they should not have economic rights and the rest of the country should stop economic engagement with them. This falls within the UAPA definition.
Can he get away? Can the MP get away by saying, look, I did not specifically refer to the word Muslim? Can he get away or is that disingenuous?
I'm sorry. I mean, anybody who watches that statement, does it leave doubt in anybody's mind? I mean, the law is not a fool, right? The law is not a fool. Anybody who watches that statement knows exactly what he's referring to. The audience has understood who he's referring to. The audience response is clear who he's referring to. Everybody has understood. Right. So the law is not a fool. So therefore, it's obvious what he has said is clearly a hate speech against a group of citizens of this country. And the problem is with the enforcement. Delhi police has registered a FIR without even naming him. It's a real joke. What is the purpose of a FIR? He should have been The FIR should have named him. The speech is very clear, and action in law should have been taken.
You know, that's absolutely where I want to come to you, Mr. Neeraj Kumar, because, you know, the fact is this is not the first instance where Parvesh Verma, a member of parliament, is resorting to this kind of hate speech. This is the same person who spoke during, just before the last election, saying Shaheen Bagh protesters are potential rapists and murderers. This is the person who said we will demolish mosques on Delhi government land, raise the mosques illegally built on government land. Now is going to the extent of an economic boycott, and as has been suggested by Mr. Parasad, not named. The others in the same Virat Sammelan, Mahant and others, have passed even worse speeches. Yogeshwar Acharya, Mahant Naval Kishore Das were even more explicit, and yet the FIR is against unnamed persons.
Well, first of all, I don't know the details of the FIR and what are the contents of it, but let's assume that there has been an FIR for hate speech and Paresh Verma has not been named as an accused. The point is that the investigation agencies have the problem when they have to look for a complainant who has to come forward and say that I have been incited, I have got outraged, or my religious feelings are hurt. So one approach is that the police should be the complainant itself. That is quite possible. But then to prove that it has outraged the feelings of the other community, and it has outraged to such an extent that it is going to lead to communal violence and so on and so forth, that becomes a problem.
No, are you saying, Mr. Kumar? No, 1 minute. Are you saying that the police can't act suo moto? Are you telling me, or is the police in Delhi taking its instructions from the political bosses who are completely silent? I mean, the Home Ministry, not one word from the Home Minister on this, or indeed anyone senior in the government. Even BJP spokespersons are silent.
You have again jumped the gun, Rajdeep. You have not allowed me to finish.
Please go ahead.
I'm just explaining to you the practical difficulties in a case like this. We see these things in the newspapers or on television cameras, and we say that, well, it is incitement of religious feelings and it will lead to communal violence and so on and so forth. Surely they would. But somebody has to come forward and lodge a report. That is one. If nobody comes forward to report, then the police is well within its powers to register an FIR on its own complaint. But then the question will arise, how do you prove that it has outraged the feelings of the other community? People have to come forward and give such statements.
Okay.
But having said that, to nip this problem in the bud, the police should act in these cases in a proactive manner and go about registering cases immediately without waiting for any clearances or, as you are supposing. It should be seen as a proactive agency of the law and the law and order machinery.
Okay, Mr. Farasad, you want to respond?
In fact, can I say one thing here?
Yes. No, just a minute. I'll get one by one. Mr. Farasad, you were nodding your head, disagreeing.
I was nodding my head because the requirement for outraging the feeling is a requirement under 295A, which is where you attack the religion. But where you are attacking the followers of a certain religion or the people themselves, the test is fully objective. 153A, 153B is objective test. It does not depend on whether you outrage anybody's feeling at all. This is not a 295A case. This is a 153A, 153B case. It's clear-cut hate speech, objectively speaking. The police does not, and I'm sure there are enough complainants in Delhi. The problem is not a complainant. The problem clearly is he is part of the ruling party. He's a MP from the ruling party in Delhi. And the police is controlled by the ruling party. They will not let action be.
That's exactly it. Who controls the police? And therefore, will these hate speeches be allowed to continue? As I said at the outset, whichever community they belong to, we must have zero tolerance now for hate speech. Throw the law book, put the accused in the jail cell, hopefully in the same jail cell, whether they belong to one community or the other.